Did you hire a Billboard lawyer? You're hurt, bills are stacking up, and now your calls go straight to voicemail. That silence can cost you real money. I'm Steve Sweat. I've been a California personal injury attorney for 30 years, and I see this every week. People think they hired a lawyer, but their case is really sitting in a high-volume pipeline being handled by a case manager. In the next few minutes, I'm going to break down 4 structural reasons this happens, how each one cuts the value of your claim, and what you can do to protect yourself before you sign the one document that ends your case forever, the release. So let's talk about high volume firms that you usually see on billboards and how they operate. First, you need to know what a settlement mill actually is. It's not a fancy term, it's a business model. A settlement mill is a high volume personal injury firm that signs up thousands of cases, runs them through the same steps, and tries to close them fast. Speed is the product. And when speed is the product, your case can't get the time and attention it needs. Here's the first tactic I see all the time. Case managers running the file. A case manager isn't a lawyer. Sometimes they're smart and hardworking, but they're not the one who's accountable in court, and they usually can't make the real strategy calls. So what happens? They become a gatekeeper between you and the attorney whose name is on the sign. If you've ever said, I keep asking to talk to my lawyer and they tell me someone will call me back, that's this model. The attorney might show up at intake when you sign, then they might show up again when there's a settlement offer and it's time to get you to sign a release. In between, you're talking to staff. Now you might be thinking, okay, so what? As long as the case gets handled, right? Well, here's what actually happens when you can't get the real lawyer on the phone. 1, basic time-sensitive evidence gets missed, witness names go cold, businesses overwrite video fast, dash cam footage disappears, photos don't get taken the right way, and if liability, who is at fault, ends up being a fight, those early pieces of proof can be the difference between winning and losing under the preponderance standard, meaning more likely than not, 51% win. 2, your medical timeline gets sloppy. The insurance company loves gaps in treatment. They'll throw it back in your face and say, if you were really hurt, you would have gone in sooner, or you must have gotten better. That argument kills value, even when you're truly injured. 3, the wrong conversations happen with the adjuster. In a mill setup, the adjuster often controls the pace because no one is pushing the case strategically. The adjuster wants recorded statements, quick authorizations, quick settlement talks. And if your side isn't organized, you end up reacting instead of leading. Let me give you a quick example. I see this all the time. Someone calls me after they've been trying for weeks to get a straight answer. They've left message after message. Meanwhile, the adjuster is calling them directly, acting friendly, just checking in, but really collecting information, locking them into positions, and waiting for the case to weaken. So what does a boutique litigator do differently? Well, early on, we build a liability plan. We look at who's at fault, what proof we need, and what the insurance company is going to argue. Then we go get the evidence before it disappears. We also talk to you directly about the decisions that matter, not just status updates, strategy, treatment decisions, symptom tracking, what to say and not to say, what documents to sign, and what to run for the hills from. Because here's the truth, silence isn't just annoying, silence is expensive. And now, here's where it gets even more expensive. These mills are built to settle cases before a lawsuit ever gets filed. The second structural reason you don't get calls back is this. The whole system is built to settle before suit. Pre-settle, no lawsuit filed, no real pressure. And look, sometimes settling without filing is fine. If liability is clear, your treatment is done, and the offer is fair, I'm not here to tell every case needs to see the inside of a courtroom. But the mill model pushes pre-settlement because it's fast, it's predictable, and it keeps the conveyor belt moving. Here's why insurance companies love it. If you don't file a lawsuit, you don't get discovery. That means no depositions, no subpoenas, no forced production of records, no ability to put a witness under oath and lock them into a story. The adjuster can just say no, drag their feet, and make you tired. So what does that mean for you? It means there's a ceiling, a low ceiling. Insurance companies pay based on proof and risk. And if they don't feel risk of a lawsuit, risk of a jury, risk of a judge ordering documents turned over, they don't have to pay like the case is serious, even if you're seriously hurt. This is where people get stuck in low impact numbers. The adjuster acts like the crash was minor, your care was routine, and your pain is just something you should, quote, work through. And if your lawyer isn't building leverage, You're negotiating with nothing. Now here's the trap that ends cases forever, the release. A release is a document that says, I take this money and I give up my right to pursue anything else from this crash. Not just today, forever. Even if new symptoms show up, even if you later find out you had a mild brain injury or a disc problem that didn't get seen initially, once you sign it, if someone tells you they can reopen the case, run for the hills, that's not how it works. Let me give you a real example of how ugly this gets. We have a client, let's call him Marcus. He had what looked like a rear end case. He gets sent down to the pipeline, a little chiropractor, some quick notes, and the case gets settled for $18,500. Then later his symptoms go away, that he finally gets a deeper workup and gets diagnosed with a mild traumatic brain injury. At that point, he learns his injury could have been worth, in his words, somewhere in the $150,000 to maybe $500,000 plus range, depending upon what the medicine showed and how it affected his work. But it didn't matter. The release was signed, end of story. Now compare that with Sarah. Sarah had a traumatic brain injury case. The mill pushed her to take $275,000. She switched to a boutique firm that treats the case like a real TBI case, retains 4 experts, files suit, forces the issues, and she ultimately recovers $4.75 million. That's not magic, that's leverage. That's what happens when the defense has to answer hard questions under oath and the proof actually gets built. So here are the protection steps you should take before anybody talks settlement. 1, don't rush to the demand. Get stable in treatment. If you're still getting worse or you're still having symptoms, a fast settlement is usually a bad settlement. 2, document symptoms like it's your job. Headaches, sleep, balance, mood, memory, neck pain, write it down, because later the insurance company will act like it never happened. 3, follow through with referrals. If a doctor says neurology, concussion clinic, imaging, ortho, go. Not because you're trying to, quote, build a case, but because you're trying to get the right diagnosis. And 4, if you can't talk to your lawyer before a release gets sent to you, that's a red flag, a big one. Now the next part is the one nobody wants to talk about, where they send you for treatment and who that setup really benefits. So let's talk about the mill tactic on this issue. Medical mill referrals. Here's the pattern. You get into a crash, the firm signs you up fast, and then they steer you into a cookie cutter treatment pipeline. Usually it's chiropractic care 3 times a week, the notes all sound the same, and nobody's asking the deeper questions like, are you having dizziness? Any vision issues? Any brain fog? Any weakness or numbness? That's the stuff that matters. Insurance companies seize those records and they attack them. They call it routine care. They say the diagnosis is vague. They argue there's no real causation, meaning no solid link between the crash and the injury. And then they discount your damages, the money you're owed for injuries, because the medicine doesn't support a serious claim. Let's contrast that with the boutique approach, which is different. You start with a real diagnosis plan. You treat symptoms, but you also figure out what's actually wrong. If imaging is appropriate, you get it. If a specialist is appropriate, you get that referral. If a TBI screen is indicated, you do it. And you document future care if you're going to need it, because future care is part of damages. The 4th tactic is volume-based adjuster deals. This is the quiet part. High volume firms and certain adjusters see each other all day long, every day. And when you settle thousands of cases, you can fall into, quote, preferred numbers, predictable offers, fast closes, fewer lawsuits. It looks smooth, but smooth isn't always good for you. You'll feel it when the offer comes in as a, quote, take it or leave it, and the push is to sign, not to fight. And then there's a lien issue. A medical lien is basically an IOU to provide medical care paid out of your settlement. So your gross settlement might look fine, but your net, the money you actually keep, can be a punch in the gut. At a boutique firm, lien reduction is part of the job. We negotiate them down hard, because every dollar we shave off liens is a dollar that stays with you. And if you want a reminder of why early, serious work matters, let's look at the Rodriguez family trucking case. They were looking at a $450,000 offer with no real investigation. A boutique firm preserved evidence, pulled the truck's electronic records, the module data, uncovered safety issues like a disabled lane departure system, filed suit, and the case resolved for $6.2 million. That's what happens when you don't let key proof disappear. So what's the key takeaway here? If you can't reach your lawyer, your case is probably being run for speed, and speed usually means less proof, less leverage, and less money in your pocket. So if you're in California and you want a free claim review and my red flag retainer checklist, call my office or go to our website and submit your crash info. I'll tell you straight where you stand.